Hey, it's your old buddy Brian Parker on the side of the video today. Just making sure we can put up information for you here. This is going to be not so many fun things in the screen, even though I got the space for you here. It's a simple video with a big impact today. I am going to give you all of my latest letters, all the letters that I work on throughout the year that I give to you in different videos, usually accompanying securitization videos or creditor defense videos or debt buy defense videos or just videos on how to combat or settle a debt before or after litigation. So I'm going to give you the top 5 things that I want you to take away from this video. Number 1 and most important, let's put them up there, the 5 tips. Shazam. Keep a paper trail registered by mail. That is so important. 30 years of doing this, and it all comes back to, did your client send this? Mr. Parker, where's the proof? It's all about proof of service. It's amazing. I've been in situations where what's the expression? For the want of a nail, a kingdom was lost. Where the whole linchpin of the litigation is, was something sent? And then they claim, well, we never received it. This is very common. Mr. Parker says, we never received it. And then I take it out and show them signing for it. It's like a battleship turns on a dime. That's always the feeling that I get whenever I see someone lying and then suddenly the truth comes out and the battleship turns on a dime. And then they just keep talking like they never lied in the first place. So keep a paper trail registered by mail. Always give more than what is required. So if you send a dispute letter, for example, we're going to talk about that, and it says, hey, send proof, send an ID, send an ID, send an envelope of a letter you received recently. If it's an ID theft, an FDCPA affidavit, a police report, always send more than is required. Keep a copy of every signed letter, not a word copy. It may sound like keep a paper trail registered by mail, but commonly clients, I will ask them, hey, I can sue this for you. Did you send a notice? Yes, I did. And they send me a word copy. I go, well, where's the actual letter you sent? They don't have it. Bless their heart. But if you want to get something resolved, have a copy of the thing you signed. So in the instructions and letters I'm going to talk about today, it will include information signed, because that's truthful and credible. What you include in your letter, going back to what I said on number 2, is sometimes just as important as the notice of the letter. What you send with it, what's the proof? It's, as I always say in ID theft cases, it's so unfortunate that commonly all the work, the victim has to do all this work to prove a negative, that she did not take out this debt. And she's got to do a tremendous amount of work. Why should she? She wasn't the one that did anything wrong, but that's the way it is. So in that vein, keep a file of everything. It's so good to have a file where you can just go, see, either it's me representing a client or a client on their own in a situation. So my new thing now, just remember, because debt happens, harassment never should. And if you agree with that, like, love, and subscribe to this channel, and we'll keep bringing the good stuff. So all of the following that I'm going to talk about are on one video on our hundreds of video website, membership website, collectionstoppersolutions.com. You will have at your disposal when you become a member of our membership site, just on this video alone, an ID theft letter, a follow-up letter, we're going to talk about follow-up, and the instructions, a validation letter against debt buyers, collectors, and yes, creditors. You've seen plenty of my videos talking about turning the creditor into a debt collector. Let's put it up there real quick. Why not? Boom. So also the cease and desist letter. When's a cease and desist letter important? Well, we're going to talk about that today, especially in an employment context. Permissible purpose letter and a follow-up letter with instructions. That's so important. If you see someone's hit your credit, usually it's in not the soft inquiry, the hard inquiry. Hard inquiry keeps their inquiry on your credit report and drags down your scores. for 2 years. That's not good. So a credit dispute letter, an ID theft letter, will have copies of those, and also follow-up letters with instructions. And the newest letter, the securitization letter, follow-up securitization letter, instructions. So everything I just told you, I'll have Word templates for you to fit your facts and your personal information, and it's all done for you. The very latest and how we kick their butts, and a lot of the reasons why I tell you to keep a paper trail, register by mail, is because you're not going to get responses. That's why I have follow-up letters. Why am I doing that? Why are you doing that? Because an absence of a response is sometimes just as powerful as how they responded. What's going on over there? Anyway, so you have to send these letters and the follow-up letter. Again, I get it. Why are you doing all this work? Because a stitch in time saves 9. It's cliche day to day. So the first letter with instructions we're going to put up is the, let's just put it up. How to send the validation letter and follow up to debt buyers and creditors, okay? Quick takeaways. Keep a copy of the signed letter for your records and the green card when it comes back. When you send it certified, return receipt requested, you get a green card showing they signed for it. Again, you wouldn't believe how many times I hear, well, you didn't send us a letter, and then you did, and you show them. Is that your signature? That's fun stuff. They can contact you only after they validate. If they don't validate, then it's important that you send that follow-up letter. It will save you time and save you money. So if they sue you and you've asked for validation, it's not the end of their case, but it shows the court that you're proactively saying, hey, wait a minute. That hey, wait a minute is oftentimes how you win these cases. Just trust me on that. These letters, again, create a paper trail. You've got to create a paper trail and register by mail. The next is the securitization letter. So you'll get a securitization letter form template on the video and the instructions. Takeaways, you got to find the true ownership and make it an issue with creditor cases, because just about all credit receivables are securitized. When they're securitized, now someone is selling your debt to bondholders. They get a certificate. Well, that's got to be backed up by collateral. Your debt is the collateral. If the trust that it's sold to, that the owners of that trust receive proof that they own a piece of that, they have to have it backed up by the collateral, your debt. So that means they have to own it. There's always at least 2 owners in a securitized creditor case. So make that an issue. These letters help you make that an issue. So at this stage with those securitization letter, you want to send a copy of your credit report with a circled exactly what debt you want shown, or a copy of your ID and a copy of your ID. When I say a circle of your debt, meaning this is the debt I want you to show me, it was securitized. Give me the securitization. When you see the securitization letter and the follow-up letter, it'll be self-explanatory. It's a great letter. You may want to send a copy of the original contract with that letter, and you may want to send a copy of the creditor statement, just to show them more than they need to that you may owe this debt. You just want to see who owns it. Register by mail, keep a paper trail. Cease and desist letters are fantastic with this one caveat. Cease and desist letters are for when you know you don't own it, or you just want the calls and letters to stop, or if you fear they're not going to stop, have there be consequences. So once you send a cease and desist letter, they have to stop. That's the law. That's FDCPA 1692C. And if they don't, you have a case against them right away, with one caveat. Sometimes, I don't know how many times in 100, they will sue you if you stop communicating with them. But if you communicate with them and they're planning on suing you anyway, you can only do yourself harm by communicating with them. So have them stop. This is especially important when they call your work a lot And I want you to remember with cease and desist letters to keep a log of how many times they contact you and who contacts you and what date, from what phone number. That's so important. But with cease and desist letters in work contexts, you have to tell them, I cannot receive personal calls at work. I cannot receive letters at work. Once that's done and then they call again, that's actionable. Always keep a log. The next letter that'll be on the video, permissible purpose letters. You find somebody has contacted your credit, that's funny, and you're like, I didn't take out that debt. That may be the premise or the beginning of an ID theft, but you want to lock that down as fast as you can. I found in my experience that when you send these letters, they do not get responses. And that's important that you have a follow-up letter. Why? You want to show the court a paper trail. Under the Fair Credit Reporting Act, you are not allowed to sue someone that puts stuff on your credit report until you've given them a bite of the apple, which means you've sent a dispute letter. This is the one part of the FCA where you can sue without giving a letter first. I say belt and suspenders. Make sure you have sent this letter out. So you can go to the court and go, I gave them a chance. I'm not even required to send a letter. I asked them twice to tell me why they're on my credit report. Judge is going to love you for that. So you'd send a copy of the credit report page circling the debt, a copy of your ID, and a police report if you file one. It's always good that you send more than you need to. And that belt and suspenders approach is more than you need to do, but you should do it. Sending credit report dispute letters, again, you'll have one of these with the instructions. They get their bite of the apple. You must give them a chance to eliminate the debt once you complain about it. Send a copy of the credit report page with the debt circled, copy of your ID, copy of your police report if it's an ID theft, a copy of any affidavit. Yes, you may want to create an affidavit and send it along with a letter. It's powerful stuff if it has to go to litigation. And remember, keep a paper trail, registered by mail. So, those are your magnificent letters that I'm giving to you on the membership site. Template letters with instructions and show notes telling you exactly what you need from the person you're sending that letter to. Sometimes you're sending that letter knowing you're not getting a response and the follow-up is valuable. Again, Parker, why would I send a letter where I'm not getting a response? Because a lack of response sometimes is a great response, especially if you're saying, hey, validate this debt. They don't validate, then they sue you or they keep coming after you. Once you have that signed green card, you keep a copy of the letter and you have the signed green card. Incidentally, when you're sending FCRA dispute letters, I will have the addresses of all the credit bureaus, and underneath that you put whatever furnisher. A furnisher is the person that furnished you credit, and that person is to be sent a letter to if they are contacting your credit report with an impermissible purpose. One letter I forgot, very important, is the special, I'm just going to say it, but it doesn't mean much to you. It's FCRA 15 USC 1681 GE letter. And what it is when you have had your ID theft taken and you're now getting calls for people saying, hey, you bought this car, you financed it, you're not paying it. Hey, you got dental care, where's our debt? You send the furnisher. It's important that you understand, whoever gives you credit, they are furnishing you credit. So under the FCRA, those are called furnishers of credit. You send those letters, the Bank of America, GE Dental Care, whoever it is that financed somebody on your dime, you send them letters. And under the 1681 GE, they are required in less than 30 days to give you all the applications that the bad guy signed. Any letters they sent the bad guy, any account statements they sent to the bad guy. So you'll get this wealth of what's called discovery before you even file a lawsuit. And you can find out if it was your sister that did this or your ex. They have to send you this stuff. But the law, they've got lobbyists they have a right to reject you if you don't send the following information. Proof positive of the identification of you, the victim, some government-issued identification card, some information that a particular entity was contacted and you've got a hold of the proof, any kind of information that shows you did not obtain this debt for your own purposes, and that is a ID theft affidavit with the FTC or a police report. You got to overwhelm them with proof of the ID theft, because they're going to be jerks about it, because they realize they are on the hook. Their response to your letter actually puts them under the hook, because when you sue under an FCRA dispute case, you sue not only the credit bureaus, you sue the actual furnisher of the credit. So they're going to give you a hard time, but the law requires them to respond to this letter. So make sure you overwhelm them. Again, my instructions will tell you what to send. Register by mail, keep a paper trail, especially with ID theft. When you're asking essentially Cap One or Bank of America to say, hey, can you hang yourself by supplying me this information? Because that's essentially what you're asking. And that's why I've supplied you follow-up letters. Because if they still refuse and you've done a follow-up letter, it's great for you in court. It's great for you in front of a judge. No one's going to deny you gave it your best shot. And to hell with their liability or lack of liability because they didn't respond. So these are great new letters that I've created over the year, put them all on one video, attaching them all to one video, along with instructions on what to do and how to do it. And I hope it helps you. It's helped me in the past. I've used them. I love using them for myself. But it sometimes can get you out of lawsuits, or it can defend you in lawsuits, especially when the bad guy doesn't do what he's supposed to do under the law. Or if you need to sue them down the road under the FCRA. The FCRA, once you get beyond that bite of the apple provision, is quite powerful stuff. I hope this is powerful stuff, because remember, debt happens, but harassment never should. So check out our membership website for all this video and all the templates and every 290 videos we have on there. I think that's the amount. And there's got to be 1,000-word templates on there now. So go get them. Brian Parker out. I hope it helps.